Of the jury make up the issues. By the way, this answer of the defendant has called for a further pleading on behalf of the plaintiff in the nature of a reply in which plaintiff simply denies each and all the allegations and statements made and contained in defendant's answer, which are neither denied nor admitted in plaintiff's petition. So it is from these pleadings, members of the jury, together with the evidence in the case, that we determine the issues. The issues are the disputed questions of fact and are for you to determine from the evidence under the law as given you by the court. Now, as you have already sensed from the reference to the pleadings, this is an action seeking to recover the amount of $5,000 in interest represented by a note and mortgage executed by Henry O. Johnson and delivered to the defendant for a specified purpose as claimed by the plaintiff, to wit, to be deposited with the superintendent of insurance to establish or to help establish the necessary fund to qualify the defendant company to proceed with its proposed issuing of policies of insurance upon the lives of individuals. It is claimed by the plaintiff that there was an agreement between her deceased husband and the defendant company that within 5 years this note and mortgage was to be returned, canceled, and satisfaction entered of record. Defendant denies this claim of the plaintiff and alleges that the note and mortgage were given by the plaintiff's deceased husband in payment for stock in the defendant company, and that the delivery of stock was and became the consideration for this note and mortgage, and in effect claims that it thereby became a closed transaction and that they owe the plaintiff nothing. Let's try another one. The burden of proof in this case is upon the plaintiff. To entitle her to recover, she must establish her claim by a preponderance of the evidence. She must prove that the execution and delivery of this note and mortgage was simply a loan to the defendant company for a specified use for a definite time and to be returned, canceled within 5 years. She must prove that the defendant company has failed to return and release said note and mortgage as per this alleged agreement. To constitute this alleged agreement a binding obligation of the defendant company, you must further find that the defendant company authorized the same. That is, you must find that there was a meeting of the minds of the parties to the transaction. Corporations such as the defendant operate and transact business through their board of directors and officers, but a formal action of the board of directors entered of record is not the only means of authorizing and validating a contract. If you find that the board of directors and officers of this defendant company, or a majority of them in a meeting, discussed the plan of accepting notes and mortgages and authorized salesmen to solicit such for the purpose claimed by the plaintiff, it would be a binding obligation even though it may not have been entered of record. So in this case, if you find by the preponderance of the evidence that the agreement as alleged was made and that it was made under and by authority of the defending company, or having knowledge thereof ratified it and accepted the benefits thereof, and there has thereafter been a default on the part of the defending company in performing its part of the agreement, the defendant would be liable and the verdict should be for the plaintiff. Unless you so find in all of these particulars, the defendant company would not be liable and your verdict should be for the defendant.